Lawsuits often end not with a jury verdict, but with a judge's signature. Federal Rule of Civil Procedure 56 authorizes summary judgment, the mechanism to win without a trial. Summary judgment is granted only when there is no genuine dispute as to any material fact, and the moving party is entitled to judgment as a matter of law. A material fact is defined as one that might affect the outcome of the suit under the governing substantive law. A genuine dispute exists if the evidence is such that a reasonable jury could return a verdict for the non-moving party. The purpose of summary judgment is to isolate and dispose of factually unsupported claims or defenses, thereby avoiding unnecessary trials. The court must resolve all ambiguities and draw all reasonable inferences in favor of the non-moving party when considering the motion. The moving party bears the initial burden of production, demonstrating the absence of a genuine factual dispute. This burden is distinct from the ultimate burden of persuasion required at trial. If the movant has the burden of proof at trial, such as a plaintiff asserting a claim, they must submit affirmative evidence supporting every element of their claim or defense. If the movant does not have the burden of proof at trial, typically a defendant, they can meet their burden in two ways. First, by submitting affirmative evidence negating an essential element of the non-movant's claim. Second, by pointing out the absence of evidence supporting the non-movant's case, as established in Celotex Corporation v. Catrett. The movant does not need to produce evidence negating the non-movant's claims when relying on the absence of proof. Once the moving party meets its initial burden, the burden shifts to the non-moving party to show a genuine issue for trial. The non-movant cannot rely merely on the allegations or denials contained in their pleadings to defeat the motion. The non-movant must set forth specific facts, supported by evidence, demonstrating that a reasonable jury could find in their favor. The non-movant must do more than simply show there is some metaphysical doubt as to the material facts. If the non-movant fails to respond or fails to show a genuine dispute, the court may grant summary judgment, provided the movant is still entitled to judgment as a matter of law based on the record. Evidence supporting or opposing summary judgment must be admissible at trial. This evidence typically includes affidavits, declarations, depositions, answers to interrogatories, and admissions. Affidavits or declarations must be made on personal knowledge, set out facts that would be admissible in evidence, and show the affiant or declarant is competent to testify on the matters stated. Hearsay evidence or conclusory statements are insufficient to create a genuine dispute of material fact. The court must draw all reasonable inferences in the light most favorable to the non-moving party. However, those inferences must be supported by the evidence presented in the record. The court does not weigh the evidence or make credibility determinations. Those functions are reserved exclusively for the jury at trial. Summary judgment under Rule 56 tests whether there is sufficient evidence to require a trial, focusing on the factual record developed during discovery. In contrast, a motion to dismiss for failure to state a claim under Rule 12(b)(6) tests only the legal sufficiency of the complaint, assuming all factual allegations in the complaint are true. Summary judgment requires the consideration of evidence outside the pleadings, while a 12(b)(6) motion generally does not. If a court considers matters outside the pleadings on a 12(b)(6) motion, the motion must be converted into a Rule 56 motion for summary judgment, requiring notice to all parties. Summary judgment is appropriate only after adequate time for discovery has passed. A party may file a motion for summary judgment at any time until 30 days after the close of all discovery, unless a local rule or court order specifies a different time. The court must give the non-movant notice and a reasonable time to respond before granting summary judgment. A court may grant summary judgment sua sponte, meaning on its own initiative, only if the parties have been given adequate notice and an opportunity to present evidence and arguments. Partial summary judgment may be granted on specific claims, defenses, or issues, resolving only a portion of the case while leaving others for trial. The court must state on the record the reasons for granting or denying the motion. An order granting summary judgment is a final judgment, making it immediately appealable to the circuit court. An order denying summary judgment is generally interlocutory and not immediately appealable, unless certified by the district court under Rule 54(b), or falling under the collateral order doctrine. Appellate courts review a grant of summary judgment de novo. The appellate court applies the exact same Rule 56 standard as the district court. The reviewing court determines independently whether there is a genuine dispute of material fact and whether the movant is entitled to judgment as a matter of law, without deference to the district court's legal conclusions.